May it please the Court, Justice Lewis, my learned friends, Mr. Pelser and Ms. Zai, appear with me for the applicants, collectively referred to as government.
May it please the Court, my learned friends, Mr. Goodman, Marga, and I appear for this morning.
May it please the Court, my learned friends, Ms. Spanberg, Mr.
May it please the Court, Justice Lewis, Justices, I appear together with my learned Julia and Ms. Lewis for the African Center for Justice and Peace Studies being addressed in the second story in the early chapter.
May it please the Court, I appear for the Peace and Justice Initiative by the Center for Human Rights, which seek admission and its advocacy program.
Thank you. As I indicated in chambers, we'll hear the applicants first, that is government, then of course the Southern Africa Litigation Centre, Mr. Trengo, and then the Helen Suzman Foundation will have the opportunity to argue. They have been admitted as amici, or as an amicus, and then the other applicants for permission to be admitted as amici will be heard after that. We'll consider all the matters together and not adjourn to make any decisions either on whether we should grant leave to appeal or on whether we will admit the amici. With that, Mr. Gauntlet.
Thank you, Justice Lewis. If it pleases the Court, the way we would propose to deliver our oral argument is not to seek, even in an abbreviated way, to track through our heads of argument, which really stand, we would respectfully ask, as a written argument. We would think the Court would be best assisted if what we seek to do is to grapple more closely, now that we have them, the heads of argument for the other party, for SALC, and to deal to an extent with the submissions which have come in from the amici curiae in an endeavour to get to the hearts of the issues. What that would mean is we would wish to start firstly by seeking to identify what are the, as they are put, the main and subsidiary questions or issues raised by SALC. Secondly, to state our case as simply as we can. Thirdly, to examine the logic of the judgment of the full bench. Fourthly, to go to what we submit as the heart of the matter, which is the proper interpretation of Section 4.1 of the Immunities Act. Fifthly, to examine the attempt, particularly by SALC, to call in aid international customary law to argue through applying 232 and 233 of the Constitution for a different construction. Sixthly, we want to deal with their particular heart or core contention that the effect of Sections 4 and 10 of the what they call the ICC Act and we call the Implementation Act do not achieve what they contend for. Then deal with the reliance on the Genocide Convention and the Security Council resolution. Consider what we say is an alternative basis on which the application should succeed, namely that a ministerial notice was published which, properly construed, had the effect of giving the temporary immunity for which we contend at the time, and that notice was not challenged, notwithstanding a provocative statement in our answering affidavit at the time pointing that out and inviting challenge. And lastly, to deal with some multiple issues of costs, very briefly, we hope.
You haven't mentioned the fact that the full court found or held that it wouldn't appeal because the matter was moot.
Yes.
Al-Bashir had flown the nest.
Yes.
Stand it, some argument as to whether this order is appealable because it might be academic.
Now, I mean to include that in my first point, which is the omnibus point of what we understand to be SALC's main and subsidiary questions. And Justice Lewis, with respect, is entirely...
Yeah, that case will be in the Supreme Court of Appeal in Bloemfontein. For the rest of today, we'll pop in occasionally to see how matters proceed there.
This court should dismiss the application for leave to appeal. Not a word, however, is advanced in support of that proposition in their heads of argument. We respectfully submit that it is an entirely unacceptable approach in this court. We are all required in our heads of argument, if we advance propositions or seek relief, to address them in our heads of argument so the court knows and so that the other parties know. Inexplicably, in this case, where the question of the refusal of leave to appeal bulked large, as the court knows, and unfortunately necessitated the, in old language, petition to this court, it's to us incomprehensible that that argument has not been addressed. And so I must briefly, if with the court's leave, punch at shadows. I shall seek to do so.
Very briefly, please, Mr. Gauntlet, because I don't think that it merits much time.
Thank you. Milady, what we have to say about it in the most practical and simple terms is this, that the court will appreciate that the effect of the declarator granted regarding the unconstitutional conduct of government and the order issued that the serving head of a state should be arrested stand without time limit. And in fact, as it is put up before you without any challenge, SALC, while simultaneously asserting before courts that the issue is moot, has, through the other side of the mouth, said that it intends to proceed with other proceedings, such as the criminal proceedings, presaged by the, to them, useful last paragraph of the full bench judgment, signalling that such a course might be open. That's the first point. The second point is that we would have thought that on the most rudimentary reasoning, the fact that an order is made, which was not made because it related to the personality of one particular serving head of state, but to a situation, namely that a warrant exists against him, as it has done in respect of, say, President Kenyatta of Kenya, and it may in the future do in relation to other serving heads of state, did not mean that this was a butterfly in the legal landscape. Meant that this is something with very serious implications. Thirdly, the court would know that through Section 4.2, which is a mirror of Section 4.1, the same reasoning would apply to potentially hundreds of officials of the United Nations, embassies, diplomatic officials, and the like. So very shortly, subject to the court's requirement, we would respectfully submit that what the court did below in holding that it was moot was indefensible, and that we say that the point, as we've said in our heads of argument, is not responsibly taken. If it was responsibly taken, it's something which should be vindicated, asserted through the heads of argument in a way that could be grappled with. The time of the court below was wasted. Getting to this court resulted in wasted time, and this court's time has been wasted by what we respectfully submit is simply not a reasonable proposition.
You said a moment ago that the declaratory order was unlimited as to time.
Yes.
But as I read the order conveniently available at page 118, it spoke to the conduct of the government, if I may adopt your nomenclature,
Yes.
at the time. It didn't speak to any future occasion or anything of the sort. It simply said the conduct of the respondents, to the extent that they have failed, which is past tense, to take steps to arrest and detain President al-Bashir, is inconsistent with the Constitution.
Yes.
That's a statement of past matters. It's not a statement of future events.
No, I don't mean to assert that it's a statement of future events, other than that it would operate in a way supportive of the order which next follows, and which I assume your Lordship would accept, operates entirely in futura.
Well, I'm not entirely sure that's so, because it speaks as to the date when the order was granted. But it ties in with another concern I have, Mr. Gauntlet. In the opposing affidavit delivered on behalf of the government by Ms. Sindani, paragraph 3, from pages 51 through to 59 of the papers, she set out in some detail the justification for the government not taking steps against President al-Bashir. And as I read that paragraph, the only justification advanced was the agreement
I'm sorry, Justice Wallace, I've been distracted by some whispering behind me. Thank you. Sorry.
It's all right. Be distracted by the whispering in front of you, Mr.
Indeed.
Gauntlet.
Thank you.
As I read that paragraph, it says that the basis and the justification advanced by the government was we've concluded an agreement with the AU in regard to the conduct of the summit. That agreement affords President al-Bashir immunity from arrest, and that's been reinforced by the decision of the Cabinet, which is referred to in Dr. Labisi's affidavit, and the proclamation made by the Minister. And that was the only ground advanced for saying this is why we as the government have not caused President al-Bashir to be arrested. Is that a correct understanding of the approach adopted by your predecessor in the High Court?
What Justice Wallace leaves out of consideration are two things with respect. One is the realities which pertained, which is that the High Court judge presiding on the Sunday expected affidavits dealing with this issue to be prepared in a matter of hours. Well, they were prepared, and to the distress of the court, only filed the next day. They were prepared in circumstances where it was clear that what the court was operating urgently, and the answer was given urgently. If what Justice Wallace is suggesting, that there's a single legal argument encompassed in our argument which is not entertainable by virtue of that answering affidavit, we would respectfully say that that could not be correct.
Well, perhaps you could actually answer the question, Mr. Gauntlet. Was in fact the argument in the court below an argument based on the propositions I've put to you in paragraph 3 of Ms. Sindani's affidavit?
Substantially, as I understand it, Justice Wallace, but like you, I have no benefit other than what is in the judgment and in the papers.
Well, if one looks at what is in the judgment, that is the way in which the High Court articulated the issue before it. So that's what it said in its introduction at page 118 in paragraph 1. Directly posed, the question is whether a cabinet resolution coupled with a ministerial notice are capable of suspending this country's duty to arrest a head of state, against whom the ICC has issued arrest warrants for war crimes, crimes against humanity and genocide. And if you'd like me to cut to the chase, Mr. Gauntlet, what I'm concerned about is we now have a mountain of paper, an argument that is developed on the construction of the Implementation Act and the Diplomatic Immunities Act, on authorities which were not cited, were not before the court below, were not raised at all, and we are asked to entertain these arguments in an application for leave to appeal as a court of first instance, and doing so under some of the time constraints that you complain of in the court below, but I seem to recall from an earlier life of mine that doing things urgently is something that members of the bar are required to do regularly.
Yeah, I wasn't complaining, I was explaining, Justice Wallace. But Justice Wallace, to answer the point, what matters we respectfully submit is whether any of the propositions of law which we advance on appeal are precluded by the ambit of the answering affidavit. if, as a consequence of the fact that the matter was heard, and it happens at times, as the Court well knows, the Court will recall in emergency years, and Justice Wallace was a combatant in those trenches like Sinoli, if a court at first instance does hear a matter urgently in relation to banning of meetings or the like, and it is wrong in law, and part of the wrongness in law may be the inadequacy of the argument of the parties before it. On appeal, the issue will simply be, it's a pity that in fact there wasn't more argument on appeal, on first instance. It's a pity that the court didn't have more time, and it may be a pity that the court below didn't do a better job. The simple issue is whether I'm precluded.
Any new facts, Mr. Gauntlet, that we need to take into account in order to consider the argument that government now advances?
No.
So the only things that were not traversed by the court of first instance are principles of law.
Absolutely, Justice Lewis. That's exactly the focus of our argument. And reverting to the beginning of Justice Wallace's question, which went to the issue of mootness, we do not with respect accept that the terms of the either the declarator or the standing order for arrest are such that if the President of Sudan comes to the country next week for urgent medical attention or for an urgent visit relating to the situation in Darfur and peacemaking or any other consideration, we do not accept. And we would invite our learned friends to indicate, if they so construe, that the order is such that it means nothing and that the President could come and go without any consequence. We say it's not the way either order reads, and we say also that when Justice Wallace raises for debate the question whether the declaratory order is purely historical, even if it were so, my clients came to this court and said, an order has been made that we behaved unconstitutionally in what we do. In terms of the relations between government and the courts, it's very important for us to clarify whether that is wrong, because for the reasons I've indicated, this is clearly not some weird and wonderful chance situation of the arrest of somebody who happens to be passing through Cape Town from Singapore to Rio de Janeiro with no possible anticipation whatsoever. What is clear, he's a serving state in Africa. He's the serving head of state of another member of the African Union. South Africa is engaged in the African Union, and as the gathering in Johannesburg pointed out, would from time to time it may be expected be the host for those meetings. So for both those reasons, we would respectfully submit that the mootness basis of the argument of the court below, or the finding of the court below, was unfortunate, not quite as unfortunate as its finding on the merits, where it was indicated, and it's accepted by counsel, that we should not trouble ourselves in dealing with prospects of success. We should deal only with merits, and we are then faced with a judgment which goes against us on both.
Yes, well, we don't have to deal with that. You have made your point at some length in your heads of argument.
May I then...
Sorry, just one final question, because my questions weren't directed at the issue of mootness. They were directed at the question of whether leave to appeal should be granted. Now, you've cited the points, the cases which say that if there's a discrete question of law of public interest, even if matters were moot, the court will hear it. But there's another string to that bow, isn't there? And that is whether it is in the interests of justice that leave should be granted. And that has been mightily developed by the Constitutional Court, which has frequently said that where interesting, difficult and important points of law arise, but are raised late or are raised for the first time on appeal, it is not in the interests of justice that the court should entertain them. And it then refuses leave to appeal, leaving them to be raised at a more appropriate time in the future. And so my questions were really directed at that issue, which I don't think you've addressed.
We respectfully submit that if it isn't moot, which I understood to be the first thrust of what was being put to me, if it is not, cannot reasonably be argued to be moot for the reasons I've given, Then the second issue which does arise is that in relation to which Justice Wallace wrote the important judgment on Mbiti Technologies by saying it's not game over, a court may still look at the issue for the reasons that he gives. The suggestion that in this case, because of the circumstances in which the application had to be heard, which was in circumstances of extreme urgency, that the questions of law now ex hypothesi what I argued before, permissibly argued before you, that those matters are matters which somehow should be put off for another day, we respectfully submit is wrong. This court in pre-constitutional years in cases like LTA construction versus CCAT engineering, the judgment of Justice Janssen, also I recall in LDC Development Bank versus Lipschitz, or Standard Bank versus Lipschitz,
UDC Bank.
Dealt with the issue of when counsel gets up in the appeal and argues points of law which are completely new, as long as they're encompassed by the pleadings and the evidence, the court will say, well, we've got to deal with it. We're not assisted as it is below. So with great respect on any level, we would submit that there's no basis to consider that it's moot, and furthermore that even
the new issues of law that the appeal raises?
The new issues fall into what I've said is the long-established basis that this court would deal with them, as it deals very often with new issues of law raised on appeal, either because counsel were too dim or the judge was too busy below to deal with it. And if it's in the game, it's in the game. And we submit that this is such an instance. So now, with the court's leave, move on from the non-issue of mootness, though, to analyze what we're up against in terms of argument. We've said, first of all, SALC is silent on leave to appeal, and we say unacceptably so. There should have been an argument that could be grappled with. And secondly, you'll notice overall SALC does not come to grips anywhere. Does not come to grips anywhere with the distinction between immunity ratione personae and ratione materia, and we'll deal with that later. Thirdly, a large part of SALC's argument pleaded was that constitutional law had, Freudian slip, that international customary law had developed to exclude reliance on personal immunity. It's had to row back incrementally on that in its heads of argument, and the high watermark of its heads of argument now is that Professor Dugard has it right when he says that international customary law is poised to move to a situation which would exclude personal immunity, but again, in his language, it's in a state of flux. Well,
isn't the state of flux caused not only by a developing attitude towards law in a global community, but also by the introduction of treaties, such as the Rome Statute, which changed the game in relation to immunities, when one is dealing with crimes such as genocide, torture?
What we're going to say is that it's all very well, but in a little article we intimated to Justice Lewis presiding, we're going to ask leave to hand up because it came to us late, by the premier professor or chair in public law at the University College of London. He says that a few swallows have not made a summer, and that the position is unequivocally so that if you ask the stark question, after, as Justice Lewis says, noting that there are trends in treaty obligations in that direction, is it? That's not the question that Professor Dugard and those who go with him allow to be asked, because they know what the answer is. Or when Professor Dugard does answer it, as we quote in our heads of argument, he gives the only possible answer, which is that we're not there yet. And so as a matter of statement of international customary law, if it does come into the debate and is considered, we're saying that the conclusion is exactly, even on SALC's approach, no more than a state of flux, no more than poised, which must mean not there yet.
How does this court, sitting as a court of a country,
yes,
not an international court,
yes,
how do we determine what is the content of international law on this topic? Do we derive it from, is there any hierarchy of courts and tribunals? Much of the material we've been given is academic writing from various sources.
Well, with respect, we would say that that's a position which goes back to Pan American Airlines in the 60s, Justice Rumpf asking and dealing with much the same question. And it's ultimately establishing, first of all, the pronouncements of the international courts, such as the ICJ, what it has to say. We also will look at what the ICC has to say about the ICC. And when you have a judge sitting in a pre-trial chamber late on a Saturday night before our case is to be heard, and he opines on whether or not South Africa is bound, South Africa has no operative immunity, he can't do that. It can only be done by a South African court. What he can certainly opine on is and some authority, sitting, as in that instance, one judge in what is a chamber court, but is the position of the ICC. But Justice Wallace's question goes to the heart of the difficulty in the matter, and that is that each domestic court would, in instances, have to pronounce on its understanding of what international law is. And I believe in the end it would be in the same way as each domestic court may, in certain circumstances, have to say what is current New York commercial law on a particular point. It would have to reach its conclusion, and in doing so, it would take into account hierarchy of pronouncements, etc., by the New York courts. But ultimately, this court reaches its goal.
Look at the domestic statutes.
I'm sorry?
Why wouldn't the court sitting on a Saturday night in chambers look at the domestic statutes?
Oh, you mean the ICC chamber court?
It's the...
Well, you see, we would suggest...
No, I'm referring to the court that dealt with the urgent application.
Oh, absolutely. But I'll tell you why.
It would look at the Implementation Act, as you call it, and it would look at the Immunities Act, and it would have regard to the Constitution, and without resort to bundles and bundles and bundles of academic treaties, it would be able to make a determination on what South Africa's obligations are.
And I would like to show you now, Justice Lewis and members of the court, that that's the fine point of the appeal, that where the court below with respect went wrong, it was beguiled, even in those compressed circumstances, beguiled by advocates and listened too long to them. It really came to the issue before it, where government was saying, I stand on one of two legs. And government, let me say, in those urgent circumstances, not saying it perfectly, but the points were there. The one is that Section 4 gives immunity to all, civil and criminal, absolute, for anything from genocide to parking offences, for anything from fraud to anything else, to a serving head of state, for as long as you are the serving head of state. Your day will come. The same way as in many countries constitutionally there's been the problem, how do you deal with a Richard Nixon? And the answer given constitutionally often is you suffer him until his removal. You can't prosecute him in the meanwhile. And the presiding judge's question goes to the heart of the matter.
It's with the presiding judge, if his attention...
you, Justice, not that presiding judge.
I see. Well, any judge, having looked at Section 4, which the court, in the month that it had to give reasons, apparently didn't do particularly carefully, and would have looked at Section 5, and then would have looked at the provisions of the Rome Statute, and it would have said, what is the purpose of the Rome Statute but to change the law insofar as immunities of a head of state accused of international crimes? What would that be?
Yes. Well,
is there any purpose in the Rome Statute if Section 4 of the Immunities Act is going to oust the provisions of this later legislation?
That I would like to show, because that is the nub of the matter, where you have two statutes effectively made, both post-constitutional, both within about 6 months of the dates of assent were about 6 months apart in 2002. And the question...
If I could just interrupt you there. The Immunities Act is hardly a new thing.
No.
It's had many predecessors.
Exactly. And if we are further correct that what the Immunities Act did was to say, effectively, we are going to domesticate, almost in the words of one syllable, the very ancient, criticize if you like, but very ancient customary international law rule. And that is a serving head of state or his or her legate enjoy absolute immunity, because that's what the world requires. International relations require wicked people to be talked to. It happened in Vietnam. It happened at Lancaster House. It happened when President Mandela went to make peace between President Mobutu and the aspirant President Kabila. It happens and continues to happen in the flawed world in which we live.
Yes, and there's very good reason for it, as you point out. Nonetheless, the purpose of the Implementation Act, the preamble to the Act, Section 3 of the Act, and all its provisions change the game, do they not?
That is exactly where Justice Lewis and I'm sure you would be open to argument on the fact that it didn't change the game, because the only way it could change the game is in a way with which SALC and those who align themselves with SALC struggle. They can't say it was repealed. They don't say it was repealed by the later Act. They don't say...
It doesn't need to be repealed, because it stands insofar as the head of state is not accused of international crimes.
No, Justice Lewis, because what we say is that if you start with the proposition that you have a second act which comes, and what could be the purpose of the second act but to do why? Our learned friends do that in their argument, and it's understandable good advocacy to go for that, which is to say, let's look at why, i.e. the ICC Act, the Implementation Act. Let's look at that. And let's also then go, and that is with decreasing confidence, into customary international law itself.
Now, that is just to give you a snippet of what's happening live at the al-Bashir case at the Supreme Court of Appeal. And previously to that, our reporter, Mbali Sibinyoni, giving us...
In the ICC Act, that is to say that heads of state in a domestic court will not be able to invoke immunity. We say, if you start the other way around, which is to start with the first act, if we are wrong, and it does not, as a matter of interpretation, say a serving head of state has immunity, then we have no other place to go other than the Section 5 notice. That's why we have the two legs to the argument. But if...
It's very much as narrow as that, isn't it?
It does, absolutely. For us it is. And Justice Ponel's respect is correct. And on section, it then becomes this. If one reasons in the normal way lawyers do, sequentially and chronologically, to say, well, there's a reliance placed on section 4 of the Immunities Act, which is adopted then. Let's just start there. What does that as a statutory provision mean? If you come to an answer, and that answer you cannot come to by saying, no, but quickly look at the later act. That will tell you what that act meant. What it means is what it meant when it came into operation, 6 months before the other. And then the question is, does the later act repeal it? And this is critical because Justice Lewis put to me a moment ago another way, or perhaps we have, but this is where our learned friends get into difficulty. Because when one starts to use words which are popular only in certain card games, or more latterly, unfortunately, in American politics, like Trump, you have to ask yourself, what does it mean to a lawyer? You can understand it when you're talking about a hierarchy of statutes, then we all talk in the shorthand that the Act trumps the regulation of the Constitution.
Let's not talk about trumping, because I don't understand card games. But let's look at Section 4 of the Immunities Act and Section 4 of the Implementation Act, and read them side by side. And the one says a head of state is immune from the criminal and civil jurisdiction of the courts of the Republic and enjoys such immunities as, and it lists a whole lot. And the other, Section 4, in the chapter on the jurisdiction of South African courts and the institution of prosecutions in South African courts in respect of crimes, says, despite anything to the contrary in any other law of the Republic, any person who commits a crime is guilty of an offence and is liable on conviction to a fine or imprisonment, and so on. It's neither. Despite any other law to the contrary, this is subsection 2, including customary and conventional international law, the fact that a person is or was a head of state or government, a member of government, is neither, and this is B1, offence to a crime nor to a ground for any possible reduction of sentence. Now, forgetting about what is actually before the court, and that is the question of arrest, not prosecution in a South African court. How do you read the two sections 4 together and say that is international crimes?
But then, Justice Lewis, we would submit clear to what we're doing. Because what Justice Lewis is positing to me is that we put the two acts side by side to construe them. I'm saying that the first thing to do is to establish a meaning which is to be given to the first act at the time it's enacted. That meaning, as a matter of interpretation, can't change because there's a later act.
No, the meaning of the Immunities Act doesn't change at all. What the Rome Statute does, as I understand it, is say heads of state who are accused of international crimes do not have the benefit of Section 4 of the Immunities Act.
No, it doesn't do that. Because if it wanted to do that, it could have said that so easily. What it is doing is dealing with a different topic. And the topic is saying this, that a head of state, like any other, and any army officer or etc., elected representative, if that person faces trial in a South African court, as it may do under this Act, for an act committed in Rwanda or somewhere else, then in that trial, it cannot say my defense is I was the head of state and I have immunity. And likewise, that person cannot say that you have to give me a lesser sentence because my finger wasn't on the actual machine gun, I was higher up in the hierarchy. It is contemplating a situation in which you can have a person, and that's why the language is or was a head of state. So take President Bashir. President Bashir, at a future stage, would lose his Section 4 of the Immunities Act, immunity in South Africa. He would then face trial, arguably, conceptually, in South Africa. In those circumstances, at the end of his trial, because he couldn't invoke to keep out of the trial the Section 4 of the Immunities Act immunity, or secondly, I forgot to mention, it's been waived. Sudan has said, well, actually...
That's another argument.
No, but it's important. You can't pigeonhole them, Justice Lewis. It's important at this stage to recognize the difference between the two Section 4s is the first Section 4 is saying, as a matter of interpretation, an unchanging meaning at the time and now, that if you are a serving head of state, no matter what turpitude you've done civilly or criminally, you enjoy immunity. Section 4 of the ICC Act is saying that despite anything in any other law, a person who is or was a head of state and is on trial...
The is bit is what is important. You've started your argument with now the person is no longer a head of state. I'm concerned with is
and that is why, with respect, when I gave the answer to the is point, and Justice Lewis sought to push it aside by saying waiver is a different point, it's an actual point here. Because what could happen is that Sudan could waive that immunity. And if Sudan waives that immunity, then he is still a president. It's very conceptually difficult, practically difficult to see that it may happen. But that is the purpose of it, is to deal with the fact that if the trial takes place, then when you reach the end, there is to be, and that's the important thrust of the ICC Act, there is to be no distinction between sovereigns and foot soldiers. If you were involved in one of the listed crimes, then when it comes to the question of whether or not you committed it and the sentence, you are treated absolutely equally.
In other words, what you say Section 4 does in the Implementation Act is replicate in respect of criminal charges in South Africa, which our courts are given jurisdiction over, the provisions of Article 27 of the Rome Statute, which says exactly the same thing and which dates back to the Nuremberg trials. It's no good coming to this tribunal once you're before it and being properly charged before it and saying, but I was a head of state. That's not a defence. It doesn't mitigate your sentence. And you say that leaves Section 4 of the Immunities Act untouched. But then can we look at Section 4 of the Immunities Act?
Yes, well, that's what I've been trying to do for a long time, so I would very much like to.
Please finish what you have to say in response to Justice Lewis. I want to come back to the Immunities Act.
With respect, Justice Wallace, since he asked me if that's a correct statement of what we say, it is absolutely that. And we say that the purpose of the ICC Act is to bring down into domestic law the obligation created by South Africa for itself at international law level. And part of that, through the Rome Treaty, is that kings and foot soldiers, when it comes to the crime, they must do the time, that they are not to be able to invoke at the end of the trial a defense or a sentence. But there are the two instances which I've given, namely the situation where the person ceases to be a head of state, so and it's recognized by was, so falls within, and the second one being an instance where there's been a waiver. So that is the gap which opens up between them. So then we say, and Justice Wallace is right to put it that way, we then say, and it's the thing we try to say first, let's first look at Section 4, let's see what it does, and if it was changed by what happens, and we submit not. So I go to Section 4 of the Immunities Act, and it says the head of state is immune from the civil and criminal jurisdiction. Now, then our learned friends say we rely on 4.1a. We don't rely on 4.1a.
Before we get to 4.1a,
yes.
It says immune from the criminal and civil jurisdiction of the courts of the Republic. It's not referring to the International Criminal Court. And the court of first instance was not asked to prosecute, it was asked merely to stop the departure of al-Bashir and to order his arrest.
The order sought was an order we trust which was sought within jurisdiction of the High Court, because if it was an order not being sought within the jurisdiction of the High Court in Pretoria, its short answer would have been, we can't deal with this.
That isn't the point, Mr. Gauntlet. Surely the point is this. The immunity is given from the criminal and civil jurisdiction of South African courts, where in the process, let's forget that there was a fight where your clients, the government, were alleged not to have done what they should have done. Let's assume they'd done what Mr. Trengove's clients say they should have done. Assume they had arrested him. The only engagement with a South African court would have been under Section 10.5 of the Implementation Act, which would have involved an inquiry not sitting in the exercise of its criminal and civil jurisdiction, but in the exercise of its special jurisdiction under the Implementation Act, to say, is this the right person? Is there a warrant? And should they be surrendered to the ICC? So when we start, as you ask us to start, and you may well be right about that, with is immune from the criminal and civil jurisdiction, where in what they sought to force the government to do was President al-Bashir being submitted to the criminal and civil jurisdiction of our courts.
We thought the answer was easy, Justice Wallace.
Well, I didn't find it easy, so I'd be grateful for your help.
We thought the answer was clear in that the language, firstly, of 4, talking about the criminal and civil jurisdiction of the courts of South Africa, means that whenever the courts of South Africa have jurisdiction in a matter, there will be such immunity. Immunity, 6 months, jurisdiction of the South African courts was extended 6 months later through the operation of the ICC Act to enable people who were subject to arrest at the instance of an ICC warrant to be drawn into the jurisdiction of the South African court. And that you would see starting in Section 8.2 of the ICC Act, as it's called, because it's got to go, the request is received, it goes to a magistrate who must endorse it, and so it goes on through Section 9 with procedures for how the warrants, etc., work, and then into Section 10.
No, Section 9 deals with provisional warrants which have nothing to do with this case at all. That's urgent warrants. This is a Section 8 case, followed by Section 10.
Wallace, I'm dealing with the issue of principle, and you asked me.
Can we deal with the question of principle on this basis? And I appreciate it's hypothetical. If instead of saying that the arrest warrant should be forwarded to a magistrate, it had been endorsed by the central authority, who's the Director General, and after it had been served, presumably by some policeman or other, instead of the matter going before a magistrate under Section 10, there's no requirement of the Rome Statute that it should. It had simply been dealt with administratively within the departments concerned, Home Affairs, Police, or whoever. There would be no question of a breach of Section 4 of the Immunities Act, would there? And that's why I put to you the question about the civil and criminal jurisdiction of the court. If this process was purely within the administration and the Implementation Act had not said magistrate, surely we couldn't be having this argument.
No, but that's because, Justice Wallace, I hadn't finished the submission, which is, it starts, I said, with 8. 9 applies, as its heading tells us all, to provisional warrants. And then 10 says what follows. And that is a proceeding before a competent court after arrest for purposes of surrender. So you end up in a South African court.
I just want to put this in the perspective that we have 2 international arrest warrants against President al-Bashir. They were issued against the background of a UN Security Council resolution asking states to cooperate. Now, I think in the specter of our constitutional dispensation, where under Section 232 and 233 we have to honor our international law obligations, I find it difficult to follow how you, in answering my brother Wallace's question about civil and criminal jurisdiction of South African courts, well, surely we are dealing here with a request to a state party to assist and to cooperate to arrest President al-Bashir to eventually stand trial before the ICC. Now, I don't understand how you restrict yourself to Section 4.1 of the Immunities Act without having regard to our international law obligations under the Rome Statute and under the Implementation Act.
And under the Constitution.
Yes. Well, may I deal with that? But I need first, and I'm not evading Justice Majid, I need first to deal with 4, and then I need to come to the effects later, such as the reliance where it fits.
4 of the Immunities Act.
Of the Immunities Act. I need to consider the effect on that of Section 4 of the ICC Act, read with provisions, such other provisions as are called in aid, such as 10.9 and 10.5. I need also to say, is anything changed in that answer by, as Justice Majid puts to me, there was a UN Security Council resolution, to which my short answer is going to be that UN Security Council resolution, and we rather thought that this was accepted in this court, itself created no obligation on South Africa. What it was is it created an obligation, to the extent it could, on participants in the Darfur struggle, and then ended with a call, I think the word is, but to other states to assist.
Except that resolution, we know that the ICC normally would only have jurisdiction over cases where the crime is committed in a particular state or the person is a resident in that state. But the resolution creates jurisdiction for the ICC as an exception. And I mean, that's important because we are dealing here with a request to arrest to stand trial before the ICC.
No, that is with respect correct. The United Nations Security Council, 3 permanent members of which are fastidious non-signatories themselves to the Rome Statute, adopted such a resolution creating jurisdiction for the ICC, effectively then to bring what it could to bear in relation to President al-Bashir. As Justice Majid points out, there were 2 warrants which were issued. The interesting thing about this case, and we don't want to get involved in the intestinal detail of 8, 9, or 10 particularly, but what happened in this case, as you know, there was an approach to Justice Fabricius sitting as a High Court judge saying, please use 41K of the Criminal Procedure Act. Arrest that man. So what happened was effectively an interesting bypass. It's a point we note in one of our grounds of appeal, but there was a bypass of the actual procedure under the Act. And what I'm tracking at the moment, and I must get back to the point, which is that where it culminates in, if you are so arrested, it culminates in proceedings before a South African court. And our argument is very simple, that when Section 4.1 of the Immunities Act creates in its terms, well, domesticates, recognizes, puts beyond debate the old rule of customary international law, which is absolute immunity for the duration of your office when you are a head of state, that what that immunity encompasses is that you don't lose your liberty. You don't get arrested. You do not get taken before a South African court.
Inquiry. Why is that the exercise of the criminal or civil jurisdiction of our courts as opposed to an inquiry in terms of the Insolvency Act, which takes place before a magistrate, an inquiry under the Companies Act, or all the manifest things? Magistrates have for many, many years in this country done things which have nothing to do with the judicial function. That's what the Constitutional Court dealt with in personal injuries and recently dealt with in the Performing Animals Act case.
There is one question for us all then, Justice Wallace. On the 15th of June last year, when Justice Fabricius convened the Pretoria High Court and made orders, and there were the subsequent orders, temporary orders made, and then the final order, whether what was being exercised was civil or criminal jurisdiction of a South African court.
Jurisdiction of al-Bashir?
Not yet, no, but it was certainly a jurisdiction which was being exercised, and if it wasn't criminal, it was civil. And that doesn't get one then anywhere other than saying it's still within 4.1. But with respect, there has to be a reality check, because the reality check we submit is this. What is the scheme and the intention of saying in Section 4.1 of the Immunities Act? Very simply, anyone, as long as they're head of a state, that person must be untouchable in our country for that period, civilly or criminally. That's the purpose of interpretation.
Earlier, in relation to Section 4 of the Implementation Act, is that the head of state loses immunity when he or she ceases to be head of state, or when he or she has waived immunity. And your argument, of course, is that there is no waiver despite the UN or the Security Council resolution and despite the fact that Sudan signed on to the Genocide Convention.
Yes, absolutely. Which is why I will deal with those in a moment, because they're the important aspects also raised by Justice Majid. But
it gives a very, very limited meaning to the Implementation Act. It renders it virtually purposeless.
No, because if we're talking about interpreting it purposively, we know, because it says so in the short title, the long title, and frequently afterwards in its objects and everything else, what the Implementation Act wanted to do was bring down into domestic law what the Statute of Rome was creating by South Africa's accession to it on an international law level. That treaty itself in Article 108 acknowledged that immunities would be, existent immunities would be unaffected. It was not saying that
in relation to this category of offences.
In relation to anything. And this is Justice Ponnen raises a terribly important issue, because there are two ways of interpreting what the Treaty of Rome was doing and then the Implementation Act. And that is whether it is saying, first of all, at the treaty level, that we are not interested in what other immunities claims there may be in Bulgaria or anywhere else in joining. When you join us, there will be, and you implement, as you are going to be required to do as a member, this act, it has the effect of destroying those immunities. And we respectfully submit that it didn't do that. The critical thing then is this. It goes back to the fundamental question. If you put the two provisions side by side, having performed the exercise, firstly, of interpreting simply and purposively the first provision, this first section 4 of the Immunities Act, what it does is to say in terms against which the other participants in this court jib. They say that can't be so. They go to international customary law. They say that it's poised to change it. It's on the edge, etc. That means that international customary law, we ask you to find, at the time that Section 4 of the Immunities Act was implemented, was four square on that position, that it said, never mind the crime. There are important reasons why the wicked must be allowed to come and be spoken to, etc., etc. Then the question is, as a matter of interpretation, given the absence of any repeal, etc., does the wording of Section 4, by referring to an is or was situation, and by contemplating then the position which arises during the conduct of any trial in South Africa as a defence to a crime or reduction of sentence, when it imposes what I've called this equality, to say if you enter that, you get no get-out-of-jail card, you get no defence, you get no special treatment on punishment. But it is not taking away what had been put into law just months before, and what we say was the lex specialis on immunities in the widest terms. And we say that far clearer language would be required to do that. And if you try to go to international law, to call in aid for the virtues, the purposes, as Justice Lewis has put to me, of in prior Section 232, 233 of the Constitution, the question then becomes, show us that international law is where you say it is. And at that stage that...
Mr. Gauntlet, simply by looking at the Rome Statute and the Implementation Act, which gives effect to it.
Well, we submit that it doesn't do that, that Section 4, to which we've been devoting much attention, doesn't have that effect, that proceedings are set in train within the jurisdiction of a South African court, as is contemplated by Section 10. There may be special proceedings, but if they have to be put under something cognated civil jurisdiction or hybrid civil or criminal, it doesn't matter, because the original Section 4 is trying to couch it as widely as possible. So we say that Section 10 does that, and we say that when Section 10.9 says the fact that the person to be surrendered is a person contemplated in 4.2 A or B does not constitute a ground for refusing to issue an order contemplated in sub 5, it is dealing with again the situation which may be that the person has ceased to be a head of state, it may be that there's been a waiver, in which case Section 4 gives that person no protection, and that person can't at the end of the process say, don't surrender me, I just want to remind you I'm a head of state.
So you would say that 10.9 is subject to the same interpretation as 4 of the Implementation Act, and where it says that the fact that the person to be surrendered is a person contemplated in Section 4, that refers to somebody who was a head of state or who is still a head of state and has waived immunity.
Yes,
so one would have to read in an enormous amount in order to adopt your interpretation.
No, I wouldn't, because the was is there. So that's the first thing. And as regards the is, the point is that if another statute has established in the simplest and widest terms that a person has immunity, then the person has immunity. And that we would say conversely that what this court would be doing would be in very strange circumstances saying that, I know that presuming that the lawgiver knows the law is always a bold statement, but here we have a 6-month gap, have a situation where the lawgiver, in making the new Section 4, as it were, the new Section 10, and uses that careful language that it's only related to the defense of the crime, to a crime, to sentence, and lastly, that on the issue of surrender, if you reach that stage, you can't raise your hand and say, I am such a person. But being such a person is a person who is not protected by Section 4.
Your submission. 2 questions. The first one is this. It would have been open under the Implementation Act to the National Director of Public Prosecutions to charge President al-Bashir when he was in this country under Section 4.3c. Open in theory. Would he, do you say that the effect of the Diplomatic Immunities Act, Section 4, is that even though he could have produced a charge sheet and wanted to prosecute him, he could not have had him arrested and brought before the court? Is that your submission?
Absolutely.
So even though he could have theoretically prosecuted him in South Africa, in practical terms he couldn't have brought him before the court. And you say that applies equally to the ICC. Because Section 4 is dealing with the jurisdiction of South African courts.
Yes.
So if he decided under 4.3c,
yes,
a man is present in the Republic,
yes,
I want to prosecute.
Yes.
So I issue the charge sheet and I say to the police, go and arrest him and bring him before the High Court, wherever. Your answer to that is they couldn't arrest him because of Section 4 of the Immunities Act.
Absolutely, because it would be, if I might...
I just want to know that is your submission.
But I just need to explain the submission, Justice Wallace. The reason for the submission is that if the whole exercise presupposes that there will be some form of presentable warrant, it presupposes that there may be a prosecuting authority, to use Professor Dugard's phrase, poised to act on it or seeks to act on it. What Section 4 simply does is to say, Mr. AG, Mr. Prosecutor General, you cannot have such a person arrested and you cannot proceed unless one of the 2 things happen. He can draw up his indictment. He can have it. He can have it ready. And no, not immediately. But that's the critical thing, Justice Lewis, because there seems to be this way of looking at the case, which is that a temporary immunity creates an encompassing impunity. It's not right. It's just a hard decision which was being made, which is to say, as I've said before, that we need to have a situation where, to quote not a jurisprudent but Professor Mr. David Cameron, no ifs, no buts, there's no way that somebody visiting this country who is a head of state can be arrested and pursued while the person has that status. And nothing, and that then is the argument, nothing. Yes. In the Rome Treaty...
That is why Mr. David Cameron hasn't signed on to the Rome Statute,
yes,
whereas South Africa has.
Yes.
The second question, going back to the Immunities Act, when the matter is referred to a magistrate under Section 10, is the magistrate exercising criminal jurisdiction, civil jurisdiction, or merely performing a function pursuant to the obligation to bring about the surrender of a person to the ICC? Is it criminal? Is it civil?
I would say, Justice Wallace, that the short answer doesn't matter because, if I might finish, because unless it is equated to an insolvency inquiry, something which is then thought to be al fresco, outside the ambit of the jurisdiction of the court, what's going on is that South Africa has entered into this relationship which says that in certain circumstances, certain people on the principle of complementarity either must be prosecuted by us or by you. And this is a preliminary step to achieving the prosecution by the ICC. So that magistrate, by statute, is exercising a jurisdiction which is going to culminate in criminal proceedings. And that cannot fastidiously be semantically disaggregated, we say, from what is intended by Section 4.
Why is it any different from the position had the various steps outlined in Section 10 been delegated to appropriate officials and not to a magistrate?
I'm sorry, I give it.
If the various steps under Section 10 had been delegated not to a magistrate, but to an appropriate official at a high level of government, why would that have been within either the criminal or the civil jurisdiction of our courts?
It wouldn't be. Justice Wallace put that to me as a hypothetical before, but what I have before me is the text of the Implementation Act, which says accurately in the marginal note, the heading to Section 10, proceedings before competent court after arrest for purposes of surrender. So it's not before an official. The court system is used. The Act has created a jurisdiction for the magistrate. The magistrate is not wearing a safari suit and sitting outside. He's in court dealing with a matter, or in chambers dealing with a matter. It's part of the jurisdiction of the court. Those are our submissions. Yes, and just, you will note in 10.1, you've got to bring that person before a magistrate in whose area of jurisdiction? What jurisdiction? Civil, criminal, it's there. So we respectfully then submit that where we are in terms of argument, as Justice Lewis would want to know from me, is that we submit that if you start, as Salk suggests, not with the first statute, but start with a treatise, start with an assertion about customary law, international customary law, which has been diluted, go back to the earlier statute, then what you effectively are seeking to do is, in this much abused term, almost read down, certainly read very restrictively the ambit of what Section 4 of the Implementation Act is saying. And we say, giving it the interpretation which I've been through as regards the advent of Section 4 of the Implementation Act, that there is nothing which can be said to repeal it, and to say that it negates it or trumps it with respect is to evade the central point. Was immunity given in the first section for in the terms which we say it was. If it wasn't, is the wording to which Justice Lewis drew attention, namely a defence to a crime, won't be a defence to a crime, won't help you on punishment, does that mean that you have no immunity of passing into the jurisdiction of the court? And we say, no, that's been spoken for. The one is dealing with the initial stage, the other one is if you're unlucky enough or to have passed into the jurisdiction of the court because one of the two factors coming into play, then the circumstances change. Now, may I then deal with the residual aspects which arise? This is that if it's not trumped or negated by the ICC Act, then the suggestion in our learned friends' heads of argument at paragraph 58 no, that's not mine. The Genocide Convention. Sorry, I wanted to go to. I've got a wrong. No.
Are you going to deal with the fact that Sudan and its president are bound by virtue of the Security Council resolution?
Yes, I am. Yes, let me deal with that.
Is that the point that you are going to?
Well, I'm going to deal with both. And the point about the Security Council resolution is addressed by our learned friends in paragraphs 51 and 52 of their heads of argument with respect in confused terms, because the submission made in the last sentence of paragraph 61 is that the effect of the Security Council resolution was to strip Sudan of any privilege, I mean immunity, that might otherwise have protected President al-Bashir from arrest and surrender to the ICC. First of all, it goes back to Justice Wallace's question. Whether or not the Security Council resolution had that effect is for this court in coming to its answer. The fact that the one judge in the what's called the South Africa ICC pretrial interlocutory case thought it had does not answer the question dispositively for this court. This court will decide whether it does. And in that regard, we again have a domestic statute. And this domestic statute was certainly not before the, clearly from his little, very short ruling, before the ICC judge in the Chamber Court. But we have, in our Immunities Act, very explicit provisions regarding how a waiver is to be effected. It deals with the United Nations, but it makes no provision for this sort of constructive waiver on which our learned friends rely. That the Security Council in saying, Sudan, you and your president have been wicked, there's going to be a case that there is the referral of the case and instructing the involved parties to cooperate. That constitutes a waiver such as meets our legal requirements. Our ones are very clear. It's quite clear that, first of all, there's no provision for the United Nations to have this sort of intervening supernumerary, what I call constructive waiver. That it somehow has the power to waive for Sudan.
You wouldn't suggest that the Security Council didn't have the power to issue that resolution?
No.
And you wouldn't suggest that it's not binding on Sudan? Your argument is simply that it can't be interpreted as the president giving up his immunity.
And our law, you can call it parochial, you can call it prudent or careful, but if you look at section 8.3, a waiver must always be express and in writing. And the notion there was clearly, if you read back into the section, that the sending state, the UN, each one in relation to its respective people may waive an immunity. And it, as I've said, makes no provision for this remarkable way in which the Security Council found itself able to be very pious about the Sudan and pack it off to the International Criminal Court when, as I've said, several members are careful to keep away themselves. We say that that is an end to that. May I just say one thing I should have mentioned?
It's not a waiver in a strict sense. But the Security Council resolution must have some effect. And as I understand it, and please correct me if I'm wrong on this, as I understand it, its effect is to make Sudan a
Yes.
party to the Rome
Yes,
Statute.
yes.
And if that is so, then Sudan agrees that a head of state who is accused of committing crimes as defined in that statute has no immunity.
No, we had the difficulty in the last proposition, Justice Lewis. It was a forceful and might be justified, it's not for any of us to say, but it's a forceful act by the Security Council to say, Sudan, you're not a signatory, but you are going to be inside the ICC's jurisdiction. We exercise a power which packs you off there. What the problem with the resolution is this: it does not address, first of all, what we say is clear from customary international law, that the sitting head of state would have immunity. And so therefore it's not expressed for the purposes of our statute. But secondly, our statute does not contemplate this form of constructive waiver. So whereas the resolution may be validly adopted, may have the effect of validly packing Sudan, it's got to be done this way. And we say that no amount of agility in relation to looking at the words what the UN did complies with these requirements. That's the argument in that regard.
Yes.
And as
I think
regards,
this might be an appropriate time at which
Thank
to
you.
take the tea adjournment. May I remind you, Mr. Gauntlet, that you needed but an hour.
Yes.
You will be afforded 15 minutes to conclude your argument when
Thank
you
you.
resume. Court adjourns.
You've got not against you.